would go to the girls' bathroom. Now, I know, that might sound old-fashioned, but to me, it seems that it's strictly common sense. The question I asked in 2011 when I testified is really, what are we doing? What are we doing? What kind of regulations are we putting in place on the Commonwealth and on our students? And when I saw these guidelines that came out from the Commissioner of Education, I said, clearly, either I don't get it, or Commissioner Chester doesn't get it. Some students may feel uncomfortable with a transgender student using the same-sex segregated restroom, locker room, or changing facility. This discomfort is not a reason to deny access to the transgender student. School administrators and counseling staff should work with students to address discomfort and to foster understanding of gender identity to create a culture that respects and values all students. Now I go back to the original example of that little. Yes, I mentioned that at the beginning.
I'm sorry, what bill was that?
1479, an act to repeal the transgender. And also in opposition to, I just don't remember the so-called act. So clearly, when we have this kind of confusion coming out of the Commissioner of Education's guidelines, I think what it speaks to is the problems that we all recognized, back when that bill was passed, that there was going to be confusion, and now we're seeing it. And what is going to take place, as I've been listening to, is that we are going to add further regulations on different businesses in the Commonwealth of Massachusetts. And I think that's something that we should recognize, that there is a cost associated with legislation, and the intent of the legislature certainly is not being followed by the Commissioner of Education. The second bill that I'm testifying in favor of is a bill that would increase penalties under the Freedom of Information Act. The Patrick administration claims that they are open and transparent. As we have found out recently with Representative O'Connell trying to get documents out of the Department of Transitional Assistance, it's virtually impossible to get documents under a very simple Freedom of Information Act. In February of 2013, I requested documents regarding a $600,000 grant that was spent from the Department of Public Health on the study of some type of sex programs that were taking place. We requested the documents in February, got a reply back in March, and it's now July the 9th, and despite going back and forth with the Department of Public Health, we still do not have our documents, despite the fact that they had told us that we were entitled to the documents. They did send us a letter requesting money. They eventually decided to waive those fees. We got an email just recently within the last several days saying that the Secretary of State's office had intervened, and they said the documents were going to be delivered on July the 3rd. They called again just a couple of days ago saying that the documents now needed to be reviewed. Now this is the governor's administration who talks about open and transparency, and yet simple document requests, $600,000 spent for reports, and they refuse to produce it. We need to put some teeth into the law so when this administration decides that it does not want to share and open up their information, we have some legislative authority to get those documents. So I would ask that you seriously consider that bill also. Thank you very much.
Thank you. Are there any questions? Representative Henry.
Thank you, Madam Chair. Just one quick question going back to your first testimony, Representative. I just had to ask he encounters a non-conforming or transgender male person, whose comfort trumps whose comfort in that situation? Or whose safety trumps whose? Because I believe that both of them need to be protected and both of them need to be safe. But where now, the way you pitched it made it seem like one's comfort was, or one safety was more important than the other safety.
I think most parents would think that if they sent their 6th grade girl into a ladies' room, that they would not have to encounter a 15-and-a-half-year-old male in that same ladies' room.
And that's based on a majority position in terms of the majority feels that way, or that?
I think common sense tells us that.
Thank you.
Seeing no other questions, thank you. Representative Sanders.
I'm here to testify on House 1674, which is the National Background Check for Department of Developmental Services, which Representative Walsh already testified on for us. It's required national background check for folks who work with individuals eventually by themselves from DES, and these folks are going to testify.
Thank you very much. I'll be brief. My name is Joshua Myra with the Massachusetts Down Syndrome Congress. Thank you for hearing all of us here today. The Massachusetts Down Syndrome Congress was established in 1983, representing about 5,000 families with Down syndrome throughout the Commonwealth. Here is the Representative Sanders said to support House Bill 1674. In recent decades, life has changed radically for people with Down syndrome. The life expectancy has gone from 30 years, from 25 to 60, over 60 years old. And the Down syndrome today are able to lead fulfilling lives in the community because of the thanks to quality education programs, good health care, and support from family and friends in the community. The services, many services that people with Down syndrome get is through the Department of Developmental Services. Along with the vendor agencies. The agencies employ approximately 14,000 workers who provide a wide array of services to people with Down syndrome and other disabilities. Under current law, those hired to work with people with developmental disabilities are required to have a state background record check. They do not have a national background check, so that's what this bill does. It would require that people who are hired for positions working with people with disabilities will also have a national background check in addition to the state. Under current law, there's just no system in place for DES and their vendors to have access to a comprehensive criminal history of potential employees who may have committed crimes outside of Massachusetts. And the result is, as Representative Walsh testified, that a lot of people are hired for positions with people with, working directly with people with disabilities who have criminal backgrounds, most commonly in northern states, in Connecticut and New Hampshire, and working directly with people with disabilities, and we have no idea that that's the case. So this bill would, in a nutshell, close this loophole by requiring that they get the national background record check through the FBI. And it's important to note that it's not all applicants that are having to undergo this national background check. It's only in the final stages when they're about to be hired that the background check is done. We have a broad coalition, as you see, of disability groups, and also working with partners in government agencies, including DES, DPS, Health and Human Services, the MDDC, BBC, all supporting this bill. So I'll leave it at that. Thank you very much.
Good afternoon, Chairwoman Clark and Chairman Flaherty and members of the Judiciary Committee. My name is Barbara Italian. I'm a former member of the Mass House and currently serve as the Director of Government Affairs for the Hartford, Massachusetts, a statewide advocacy organization for people with intellectual and developmental disabilities. I stand before you today to urge that you favorably report out House both the Massachusetts Executive Office of Public Safety and the FBI for fingerprinting of all potential employees, trainees, and volunteers whose position involves potential unsupervised contact with individuals with an intellectual or developmental disability through DBS or its vendors. Currently, applicants seeking work with those people are required to submit to a quarry cross-reference. But the ARC and many of their disability advocates have long been aware of the shortcomings in the existing quarry system. I'm concerned that quarries only cover any criminal history within the Massachusetts border. As a resident of Merrimack Valley, I am acutely aware of the fact that many New Hampshire residents take jobs in this field in the greater Lawrence, Haverhill, Newburyport, Lowell area, as I'm certain that in other parts of Massachusetts that border New York, Vermont, Connecticut, and Rhode Island have the same interstate employees working here in Massachusetts. 10 years ago, when I was a freshman legislator, I learned of a janitor from New Hampshire who was hired by the Methuen school system. That man was a registered sex offender in New Hampshire, but that information wasn't available in Massachusetts, so he was hired. That began the push then led by my colleague, then State Senator Steve DeBoer, and co-sponsored by myself to do national criminal background checks for school employees. That bill was heard through at least 4 legislative cycles, and then a horrendous case of abuse surfaced last wintertime that prompted legislative action. I'm gratified to know that there are now national background checks that will be in place for children up to age 22 since the passage of H.R. 4307, an act relative to background checks, which was passed in January of this year. That law would set up a protocol for the collection of fingerprints that meets both state and federal requirements. The Executive Office of Education website publicly acknowledges that the quarry leaves a major loophole because it includes only an individual's criminal history in Massachusetts. It is not a nationwide criminal history check. They acknowledge that Massachusetts was the only state in the nation that was not conducting national fingerprint-based criminal history checks of K through 12 employees. That law is now being worked on. In fact, there was a major rewrite in the most recent supplemental budget that you're all voting on. So that will comport with federal requirements. I likewise in the past sponsored the legislation before you today that's being championed by Marty Walsh because I was concerned about both vulnerable populations, children and disabled, being protected. Quarry checks don't go far enough. When I co-sponsored the legislation, I had always operated under the impression that the national check could replace the quarry, but I have since learned from our local Mass public safety officials that the 2 checks are complementary in nature. They work together. The lead sponsor represented Marty Walsh and all the Mass organizations who are dedicated to its passage: the Down Syndrome Congress, the Art of Mass, the Developmental Disabilities Council, Disability Law Center, Mass Association of Developmental Disabilities Providers, the Disabled Persons Protection Commission, and others are working with the Executive Office of Public Safety and the Executive Office of Health and Human Services to make the changes necessary to meet state and federal guidelines. While we understand the manner in which the mass education process will occur with a paid vendor administering the fingerprinting process, we are also aware of other methods such as in New York, where fingerprinting machines are owned by the state and large service vendors to fingerprint. And we will continue to search out how many of the other states accomplish this task. We will continue to consider the most cost-efficient way to manage this work and meet state and federal guidelines. Our recommendation, the ARC's recommendation, is that the cost of the background checks for direct support staff be underwritten by the home community-based waivers and other funding mechanisms related to other agencies. The projected cost is $35 for paraprofessionals and $55 for professionals to have this done. Over time, we expect that all costs will be absorbed by the new Chapter 257 rates that the human services world has been assured are coming. Our task of rewriting the bill is ongoing, but I would ask that this committee consider the legislation that's in its current form, judging the intent to protect our most vulnerable, and vote to move it to Ways and Means where final language can be worked out. The language report is exactly what we passed forward in the last session. I would lastly like to say that one of the core missions of government is to protect the most vulnerable in society, and passage of House 1674 which enjoys the bipartisan support of 64 House and Senate members, which provide an extra measure of protection for many vulnerable Mass residents. Another person was scheduled to testify at the Catholic Bar. He's a parent. He had to leave. But I just wanted to mention that his 34-year-old daughter who lives in a group home, he describes as defenseless and unable to mention if someone's hurting her, and that it has been reported to him 2 instances of her being abused from her group home. In one instance, she was dragged downstairs with no clothes on and received severe rub burns and a bloody back. And there was another instance as well. These things are happening. There was one recently reported in the Salem Evening News, an event that happened in the city of Lynn. And it's time that I'm so glad that we raised the bar and we're going to protect people within the education world, students, that we equally raise that bar and cover our responsible disabled citizens as well. Thank you very much.
Greetings. My name is Marl. I'm counsel to the State of Protection, which, as you know, is a small state agency that investigates abuse of persons with disabilities by their caretaker. It is out here on that wonderful tradition. I'm not going to go into more detail and tell you that the DPPC that I represent in Capital supports this bill. We are in a unique position as a state agency that has abuse. To tell you that there are hundreds, if not thousands, in the last few years of persons that have been investigated that in fact do live outside of Massachusetts. They were compared to persons that live in Massachusetts that have, for example, not been subject to court protection. What I can tell you is how many of those people have background check. So again, EPC does support this bill. We do acknowledge that the language needs to be worked out in ways and means of very few. Thank you very much.
My name is Ashley Yakanecki, and I'm a disability policy consultant at Massachusetts Developmental Disabilities Council. I will be delivering this testimony on behalf of our council member, Brianna Evans, who unfortunately was not able to attend. The council works to improve the system of support for individuals with developmental disabilities and their families, and bringing together lawmakers and advocates to make sure people with developmental disabilities are included in public policy decisions. In the words of Brianna Evans, I am a young woman with disabilities. I need caregivers to help me with my daily activities. Because I spend a large amount of my days with caregivers who help me live in the community, I recognize how important timely, state, and national background checks are to keep me and other people with developmental disabilities safe. I experienced caregivers who were mean and abusive in the past. I was able to tell someone about these instances, but many people with developmental disabilities are not able to communicate to others like I can. Due to this, it is important to be proactive and perform a number of background checks in order to become better acquainted with potential caregivers. This knowledge will hopefully prevent individuals with developmental disabilities from experiencing abuse and ultimately protect those who cannot advocate for themselves. In the past, I did not perform background checks on my potential caretakers. Unfortunately, a few negative experiences with caretakers have prompted me to now perform background checks on the individuals I welcome into my home to work with me. I support mechanisms that make it easier for people with developmental disabilities to have background checks performed in a timely manner. Once you are abused, you do not want the perpetrator to abuse anyone else. A national background check is the first step towards making the community safer for people with developmental disabilities served by DPS. In summary, House Bill 1674 will ensure that DPS and its member agencies have access to a person's comprehensive criminal background, thus taking one step closer to making sure individuals served by DPS are safe. Thank you.
First of all, I just wanted to say that this committee has repeatedly and consistently passed this legislation. Being presumptuous, the committee will do the same. This session, we were struggling to lie outside of this committee. That's the first statement I'd like to make. The second statement is, I understand from some of the testimony that there is a wish that another committee resolve some language in this. never has been, nor will it ever be the policy of this committee to have a bill leave this committee, allowing another committee to affect it. That will be done in our committee. When it leaves our committee, if another committee feels that they can improve upon our product, they will do so. But we will not be authorization to have a bill leave this committee unless we produce the best work product. That has consistently been the policy of this committee, and again, being presumptuous, we continue to be our policy.
Are there any questions? Thank you, Amy, for your next we have Professor Jennifer Levi.
Good afternoon. Appreciate the opportunity to testify today. Member Clark, Member Clarity, members of the committee. My name is Jennifer Levi. I'm the Director of Transgender Rights Project, Gay and Lesbian Advocates and Defenders. I'm an attorney who received a call from transgender people who face discrimination and harassment and public accommodations. I've also testified before this committee several times in support of the legislation that was ultimately adopted in 2011. I'm sorry that Representative Harrington isn't here today. Here at this point, you hear me reiterate what Commissioner Tynes explained, which is that the original bill, the transgender non-discrimination law that was submitted to this committee, was included protections for employment and pursuant to Chapter 151B, education pursuant to Chapter 76, as well as the public accommodations pursuant to Chapter 272. The public accommodations provisions of 272 were stripped from the bill that was ultimately passed. And so we are back before this committee to ask for the law to be made whole and complete to protect transgender people in all walks of everyday life, including access to facilities that are open to and solicit the patronage of the general public. That's the way public accommodations are defined in Chapter 272. There are 17 states, including Massachusetts, as well as the District of Columbia, that have comparable protections. It's only Massachusetts which does not have express protections for transgender people within those set of states in the context of public accommodations. I do understand that there may have been some misunderstanding at the time, and some opposed the law, although most did not, I believe, because of the ways in which it ensured equal access to transgender people in the context of bathrooms. The law that was passed did not create any exceptions for bathroom access for transgender people in schools or in the employment context, which is why the guidance that was issued by the Department of Elementary and Secondary Education is consistent with the terms of the law. I do understand that notwithstanding that, there are some people who would propose equal access for transgender people in restrooms. Any rule other than the one that has been adopted in the context of employment and in the context of schools is unworkable. And I know that a number of members of this committee worked very hard to ensure that the definition of gender identity did not protect anyone who is asserting a gender identity for an improper purpose. That's expressly within the language of the definition, and that's the same definition that would be incorporated within the provisions that would add into the law protections for transgender people in the context of public accommodations. It's the only workable rule, and we ask this committee to support House Bill 1589, Senate Bill 643.
Thank you. Are there any questions from the committee? I have a few questions for you. Going back to some of the concerns raised earlier, could this bill have passed allow a transgender woman to go into a women's locker room and change?
I appreciate the opportunity to answer that question. Yes, it would. The law would protect transgender women's access to the women's restroom. And as I said, the definition ensures that that means only someone who can assert a female gender identity for anything other than an improper purpose would be protected under the law. That is comparable to the same rule and law in 16 other states plus the District of Columbia. The federal government has issued guidance that reiterates the comparable rule. It's the only workable rule. Requiring a transgender woman to use a men's facility would effectively mean that she's excluded from using that changing facility. Requiring a transgender man, someone who has a bald head, full beard, to access the other than the men's restroom or the men's changing facility would be unworkable.
How do you respond to this issue around discomfort? How does the law accommodate for personal discomfort or representatives? How do we balance out the discomfort level?
I appreciate the opportunity to answer that question as well. And I know that Representative Lyons spoke about how an 8-year-old girl would respond. It happens that I'm here with my 8-year-old daughter. And I asked her, about this, and what she said, and she certainly had this experience, that if she is using a facility with another person who is a girl, that she would be perfectly comfortable with that. I also recognize that there are some people who are unfamiliar with this issue who may well be uncomfortable sharing a facility with someone whose life they don't understand. The purpose of non-discrimination laws has always been to work to change attitudes, including attitudes that are based on discomfort, that leads to discrimination and exclusion of people within our society. It is certainly true in the race discrimination context that exclusion of others from using basic daily facilities like a water fountain were rooted in the discomfort of having to share, having people of different races share the same water fountains at a time when people didn't understand that those differences of color didn't import any meaningful differences in the social sphere and shouldn't do so. In the context of passing sexual orientation and non-discrimination laws to ensure that gay people would be fully integrated into society, it certainly was raised. It was exactly at the heart of the military exclusion, a concern about gay people sharing locker rooms with non-gay people. We're looking to this legislation to set the tone of leadership and indeed to support the change in cultural and social views to ensure that transgender people aren't excluded from access to the very daily kinds of facilities that people have access to, first malls, shopping centers, movie theaters, and yes, locker rooms and bathrooms.
Could you also just clarify for me, even though we do not as a state cover public accommodations in the law that we passed, are there local municipalities that currently do have laws?
Yes, there are. The city of Boston is one such example that has had express protections, for example, in the housing context now for over a decade. And the report that we get back from the city of Boston and other local areas that protect the basis of public accommodations is that the only people whose lives it has changed is the transgender people who have been guaranteed access. It's harmed no one, and there have not been complaints about those protections. Thank you. I appreciate it.
Thank you very much, Chairwoman Clark and Chairman O'Leary. Appreciate you taking the opportunity. I'm here to testify on two pieces of legislation. I'm in support of House 1443, an act to protect the interests of children who are subject to restraining orders. This legislation changes existing law to allow the juvenile court to modify other courts' restraining orders in order to allow a child to have contact with their family more quickly and easily in cases where the Department of Children and Families would allow the contact. The DCF does not generally go to court requesting that the restraining order be modified or vacated, which causes the House Committee on Public Counsel Services to go and request permission. So in order to expedite things, in cases where the Department of Children and Families has no problem with removing a restraining order or lifting a restraining order, this would allow the juvenile court to address this issue. It would save time and money that we would be spending on having the counselor, both the CPCS, take the time out to go in and the cost of that, so it would be much more expeditious to allow the juvenile court to address this issue. The second bill is House 1446, which is an act relative to the Child Fatality Review Program. So this bill codifies existing practice by amending the Child Fatality Review Program's enabling statute to reflect current practices statute was adopted 13 years ago. So this legislation would allow the Department of Public Health to co-chair the state's child fatality review team with the chief medical examiner, who is the present chair, and assume the responsibility for the related administrative duties. The statewide program's goal is to decrease the incidence of preventable childhood deaths and injuries. So what this legislation would do would allow a designee to co-chair the team meeting if he or she is not available. So that would avoid canceling or delaying a meeting. And this would just allow for more efficiency in proceeding with the work that needs to be done. There are 11 local teams that meet with the local district attorney's offices to conduct multidisciplinary reviews of individuals, and the local teams formulate recommendations and bring this to the state child fatality review program. And it would just be a much more efficient way to really deal with the issues of the meetings that are canceled and want to proceed, so we can address the issues quickly rather than delay.
Are there any questions? Next we have Richard Knight and John Lee from the Department of I'm sure that you've seen in the news and newspapers recently the rise on attacks on our members, assaults. As you know, we carry probably the most precious cargo of all, and that's your grandparents, your parents, your siblings, your children. We take 1.3 million rides a day in the MBTA, and there is some great concern for those safety of not just my members, but the riding public and the public who could be outside of our equipment. In my written testimony, you'll see some cases of some arrests that were made after assaults on our members and some of the impacts. But I'm here to talk about those arrests that aren't made. I talked to leaders in both the House and Senate, to the administration, who were quite frankly surprised and in some cases shocked to learn that individuals could assault a transit worker, be it maybe a bus driver or a trolley operator, attack them, police are called, they arrive at the scene to see visual bodily injuries, being maybe a bloody nose, bloody mouth, torn clothing. Those on the vehicle, being passengers, point to the individual or individuals who assaulted the transit worker, and that individual is released. And the reason for this is because the officer did not witness the assault. This sends a very dangerous message to the public, for those who would assault us and those who witnessed this. To see that individual, even after being pointed out by several people who witnessed it, be allowed to walk away is definitely a problem. They do not distinguish between the law. Now, had that operator been in operation of the vehicle at the time of the assault, the arrest would be made. For obvious reasons, that vehicle could go out of control. If that individual was injured and lost control of the vehicle,
catastrophic results. They could jump a curb, run over people on the sidewalk, they could go off a cliff, they could go onto oncoming traffic and have a head-on collision. But for those that aren't distinguishing between the laws, they think it's open season on transit workers. They think they can attack us at will and nothing will happen to them. This is something that needs to be addressed and corrected. And it's for that reason we have this bill before this committee. These individuals need to understand that they cannot attack transit workers. And the fact that they're not distinguishing between while in operation and not in operation, we need to close that loop. Because the individual that's allowed to walk away, the next time they attack one of my members while driving that equipment. And let's not wait for that tragedy to happen. Let's fix this now. I would like to thank my sponsors and co-sponsors, some of whom couldn't be here today. I understand they will or have submitted written testimony. I gotta say, the general manager, Dr. Beverly Scott, and Chief of Police Paul McMillan at the MBTA have worked with the union very closely. They have put a campaign out there of awareness. I don't know if you've seen some of it. They've put handcuffs, arms behind the seat, so it looks like the individual in the seat has been arrested. They've made PA announcements all over the transit system, and assault on transit workers will lead to arrest. We just need your help. I hope that you will consider this and give a favorable ruling on this bill. And I have in my written testimony included all my contact information. I'll be happy to meet with anybody, talk to you on the telephone, any further information that I can provide you to assist you in this decision. I'll be more than happy to do.
Thank you, Madam Chairman. Thank you, gentlemen, for your testimony today. I'm supportive of this legislation. My hope is that we move it out of this committee as quickly as possible, get it to the floor for consideration, and you can count on my support to that end. My hope is that you'll also reach out to the other members of the legislature who actually get a chance to put things on the floor and ask them to give us that opportunity.
Thank you very much. Thank you all.
We have two witnesses who are coming together, Gladys Vega and Yesenia Alfaro.
Good afternoon, my name is Gladys Vega, I live in the city of Chelsea. I am so glad to be here and related to speak in front of you because I have worked 25 years in the city of Chelsea as the executive director of the Chelsea Collaborative, and I have dedicated my life to community organizing and making sure that the residents that are in the city of Chelsea feel that that's their home regardless if they're documented or undocumented. I'm here to attest how important it is to support the Trust Act. In our community, since the Secure Community happened, we have people that are not able to go to the Chelsea Police Department if they witness a crime, or they're afraid of speaking out because they believe that ICE is going to pick them up or they're going to be some like before. So I urge you, please, we were a community once that they had lack of respect to police and law enforcement because we were afraid of cases of police brutality. That is not the case now. But we need to make sure the law enforcement in the community continues to work together, and the Trust Act serves as that. So I want to urge you to please support access to support the Trust Act. On another issue very important to my heart is the Equal Access Bill. As I heard different people speak on it, we have a small community, a transgender community in the city of Chelsea. These community members are very important in our community. They are afraid of speaking out. They are afraid of using accommodations, public accommodations, and we need to do more about it. I mean, when I heard, speakers speak about it, I was appalled that, common sense tells what. For me, common sense was for me to find out that in order for my office to have public accommodation was to put a sign that says, we are transgender friendly bathroom, make sure you use the facility of your choice. That's it. It had no cost, nothing. So I please urge you to pass the Equal Access Bill to make the changes necessary so that we don't have an excuse to discriminate against people. Thank you very much.
Good afternoon. are afraid that once they are fingerprinted, instead of them being testifying, they will also be processed and put in the hands of ICE. Another case that we have a member of our Latino immigrant community, which is one of the projects that I did. This member just came back from Nicaragua. Her son was deported. He was stopped because he did not make a stop traffic sign, and he was fingerprinted, and then he was taken by the court. He was put in the hands of the custody of ICE. Then he was deported to Nicaragua, although his mother is a U.S. citizen who has filed a petition for her son, and due to the lack of the immigration system that we have right now, it's a long process to allow her son to become a U.S. resident. Unfortunately, now her son has to wait in Nicaragua for this to be processed, but now he has this against him that he was deported because of this traffic violation. So I'm urging just for all of you to consider and pass this, because it's creating a terrorist community instead of creating an atmosphere that everybody will be safe to contact the police. And it is also, it has cost a lot in our city, Chelsea, to build the trust from our Latino members and for our members, immigrant newcomers that are coming from Somalia and other communities, to trust the police. And we have worked really hard for this to be justified by not having a program that can help us. And by passing the Trust Act, we feel and we believe that it will restore that trust in our community.
Thank you very much. Is there any we have Lisa Eckman.
Clark, I'm Chairman of the Clarity. My name is Lisa Edmonds, and I'm here on behalf of the Women's Bar Association. We are here to support House Bill number 1177, which has been referred to today for quarter satisfaction. The Women's Bar Association is a professional association of women attorneys, judges. We are in a number of about 1,500 members currently. Our mission is full and equal participation of women in every aspect of society. It is the WBA's position that women can never achieve full and equal participation while domestic violence continues to permeate our entire society. A recent survey by the CDC, the Centers for Disease Control and Prevention, approximates that 24 people per minute in the United States of America are victims of domestic violence. This report emphasizes the importance of prevention and early intervention. Well, Massachusetts has a very proud history of protecting human rights. Our Commonwealth must take a step to recognize this epidemic of domestic violence and accordingly support legislation that would provide the Commonwealth with tools to effectively prosecute these cases. The WBA supports the Affordable Satisfaction Bill and it will positively update Massachusetts law, thereby helping victims of domestic violence. Under current law, a domestic violence case can be dismissed over the objection of the Commonwealth. This civil compromise statute dates back to the early 19th century. Ladies and gentlemen of the committee, early 19th century, I suggest to you, I don't think they knew what the term domestic violence was. I certainly would suggest that we look back in history, back in that time period, it was legal to commit domestic assault and battery. Massachusetts is one of the only states in the United States of America that allows the important satisfaction to be used in domestic violence cases over the objection of the Commonwealth. I believe it was District Attorney O'Keefe, and before that, District Attorney Ryan will talk to you about the SJC. That case in 2006, it was Commonwealth versus Movement. In that case, although the SJC looked at the statute, upholding the constitutionality of the statute, the court points out, and I quote, where the assault and battery occurs in the context of domestic violence, the abuser may be able to intimidate a partner or spouse into signing the important satisfaction. I suggest to you, if you take a careful reading at the language of Commonwealth versus Guzman, it is an invitation to the legislature to take up this antiquated and arcane law. By prohibiting the use of recording satisfaction in domestic violence cases, this bill would protect victims from being re-victimized in this inappropriate process. Victims are regularly coerced or threatened due to the recording satisfaction agreements by their abusers, making them improper. Permitting an accordant satisfaction case puts the victim in the position to bargain with the batterer and bear the responsibility of the case being prosecuted. And when you think about it, when you think about putting the person in the position of bargaining with their abuser, when you think about the civil statute and the idea that it's supposed to be based on the premises of contract law, where two people walk into the courtroom and they are supposedly on even equal footing, it defies logic that we can sit back today and say that's taking place in the courts because it's not. Because it is the same coercion, manipulation, and control that is used within the household, that is used in the courtrooms to make these victims sign the accordant satisfaction. This bill also sends a clear message that domestic violence is a serious crime against the state, and it needs to be handled in a public courtroom and not merely treated as a private injury to be handled quietly. By keeping these cases in the court system, victims and society both have the opportunity to reap the benefits of prosecution by requiring violent individuals to attend certified battery programs and be subject to incarceration and to the probation system. Senator Wolf, I would like to address the question that you brought this morning.
Senator Wolf is the other bald Dan. I'm in the House.
I'm sorry, Representative. I apologize. I would like to just address briefly your comments to the District Attorney Ryan. I can tell you what happens is when a case is subject to an accordant satisfaction, the case is automatically dismissed. And your question was judicial oversight or the oversight. Is there anything hanging over the head of the accuser? The answer is no. Because once it is signed, the case is over. And the satisfaction, some people would argue as well, the person agreed to go to counsel, the person agreed to pay the person. But who's going to watch over it? It's a hollow promise on the part of the batterer. The WBA supports us bill number 1177, and we ask everyone on this committee to give a favorable report. And thank you very much.
Thank you for your testimony. Representative
Wolf. Thank you, Madam Chairman. I want to thank you as well for your testimony today, and your points are entirely cogent and persuasive. I just draw from my own experience in this matter, where domestic violence cases frequently, perhaps even a majority of times, end in a dismissal. And the theory is that, at least during the pendency of the judicial process, there's some measure of safety for the victim. But the nature of the crime is cyclical, and so oftentimes, in serious cases particularly, you'll see repetition in the record. So you'll see assault battery dismissed, assault battery dismissed. I've seen as many as 20 or 30 cases of assault battery dismissed. And in this situation, and I think it calls out for judicial training, but according satisfaction, if the judge is satisfied that it is in fact, not coerced, at least in the moment, not to dismiss at the moment, immediately, but pretrial probation for, say, a year to be dismissed on the strength of the statute, coupled with a bail revocation warning, which hangs effectively a threat of incarceration on the finding of another violation, another arrest, and risk of harm to the victim. And I can just say from my own experience, I've seen it work ending a cycle of violence. And that's my only concern, is that we have so few tools that are effective to end that cycle. I just would hate to see one taken away.
Well, to respect your experience, I would suggest they're completely different statutes. Chapter 27687 is pretrial probation. That means a case open for a period of time when the person is subject to pre-trial conditions. That the case stays open. That is the key. The case stays open to judicial oversight, bail revocation, same type of thing. The case is open. Once an accordant and satisfaction is signed, it's done. So there's a big difference between comparing 27687, 27658, and this statute 27655.
Thank you, Madam Chair, just for one brief indulgence. If you combine both statutes, however, the court does not have the power to order a dismissal over the government's objection in any case, save for an accord and satisfaction. And so if an accord and satisfaction is presented to the court doesn't have to decide on it immediately. The court can say, I'll grant pretrial probation and in 6 months or a year dismiss it then on the basis of the accord and satisfaction of this condition. It seems to have worked in the past, but I take your point. It's a strong argument. My only concern is I don't know that continuing the cycle of violence advances the safety of the victim ultimately, but I understand your reason why.
Just briefly for what we're representing, I'm also chief of the domestic violence in the Cayman Islands office, and I've tried hundreds of cases, and that is not been experienced.
Madam Chair, if I may, it is the judge's decision whether or not to accept the accord and satisfaction.
That's true. It's up to the discretion.
And the judge may, based on the facts of the case, say that he doesn't want it. So
That's correct. I think, and I agree with that. But I think the issue with that is that when the important satisfaction is signed, once it is signed, there is no way for the judge to make sure that the satisfaction is going to be very good. Because in most cases, the satisfaction is going to be the defense attorney say, well, the couple is going to counseling, they made up, it was just, one kind of thing. But once their case is over, it's over. And if I might, I recently had a case where someone was repeatedly being beaten as they were driving down the street. And when a citizen called, the person, the police came, took the two parties out of the car, and he continues to punch her in the face. Now, there's a case that the Commonwealth can prove from here until next week. But that is the type of case that would be subject to an important satisfaction, regardless of the Commonwealth.
based on that particular case that you just cited, that's put in front of the judge. The request is made to the judge to come to the accord and satisfaction. The judge has the discretion to say no. So, by the passage of the legislation, it's removing the discretion of the judge to make a determination based on that particular case that is in front of him as to whether or not the case warrants that.
I think that's the whole issue. We're saying that these types of cases are not the types of cases that were considered when the civil compromise statute was set. And I do agree that the judges have discretion at the time. But the problem is that the suggestion is that this new statute does not heighten the severity of the type of crime, the cyclical part of domestic violence. And yes, some judges will, and some judges won't.
Well, you've mentioned that you've tried hundreds of these cases.
Yes.
And in the course of trying hundreds of these cases, have you ever encountered a case where you individually as a prosecutor would feel that that case was warranted in the satisfaction?
Absolutely. Many.
Sorry?
Many.
So in essence, by the passage of this legislation, you would be also removing your discretion.
Well, to a certain extent. But in terms of prosecuting a case, the Commonwealth always has the right to prosecute or to offer.
No, I understand that. What I'm saying is, by the passage of this legislation, you will be removing your individual discretion as a prosecutor to decide whether or not the individual case that presents itself, you would want to go into that.
That's true, in the way that it's accepted. That's correct.
That was carrying it forward. I think there are people coming to the court where it is appropriate for court to satisfaction because they're being
quality-based way.
Oh, no, I'm sorry. Thank you.
Next, we have the Zapata family.
This panel will be speaking in support of the Trust Act, and we will hear testimonies of families directly impacted by secure communities. Both Bliss kindly translate.
My name is Isabel Ivan Vega, and I came here from Mexico City to find a better life.
Estuve viviendo 10 años, 10 años viviendo muy bien, encontrando trabajo constante y dejar de trabajar y todo. Pero desgraciadamente tuve un accidente automovilístico, alguien abrió la puerta cuando yo pasaba. Tuve un accidente y después me detuvo la policía.
I've had 10 wonderful years here. I have had wonderful opportunities to work. But unfortunately, I was stopped by the police recently after a small car accident where the police detained me for driving without a license.
Por no tener licencia, por no tener la licencia del estado de Massachusetts, tuve que caer preso y me llevaron preso a la cárcel de Lowell, en Lowell.